One traffic stop can mean decades in a California prison.
Drug trafficking charges in California are serious. If you're caught selling, transporting, or importing illegal drugs, you could be facing years, sometimes even decades, behind bars. The penalties depend on the type of drug, the quantity, whether you have prior convictions, and even where the alleged crime took place. Imagine this: you're driving home when red and blue lights unexpectedly hit your rearview mirror. Minutes later, after a brief encounter and a search, an officer is pulling a sealed package out of your car and saying the words, "You're under arrest for trafficking." In California, that can mean years, even decades in state prison, plus fines, a permanent felony record, and life-changing consequences. I'm Darryl Stallworth, a California criminal defense attorney who fights severe felony cases every day. If you or someone you love is being investigated or charged with drug trafficking under laws like Health and Safety Code 11352, 11379, and 11360, this video will walk you through what the law actually says, the penalties you could be facing, how enhancements add years to a sentence, and the defenses that can protect your freedom. What you don't know about these laws can absolutely be used against you. Let's ground this in a real California scenario. Imagine this: you live in Oakland. A friend asks you to drive a duffel bag from Oakland to Stockton. You're told it's just clothes and you don't think much of it. On the way, CHP pulls you over near Tracy for speeding. They say they smell something. They pull you out of the car. The bag gets opened, and inside are several brick-style packages that test as cocaine. You're taken into custody and charged under Health and Safety Code 11352 for transporting a controlled substance like cocaine. Because you drove from Alameda County to San Joaquin County, two counties that do not touch, the district attorney adds an allegation that increases your sentencing exposure. And because of the amount in the bag, they begin pursuing weight loss measures. You might not see yourself as a trafficker, but under California law, that's precisely how the state will treat you if it believes the drugs were transported for sale. In California, drug trafficking isn't usually written as that phrase in the statute. It's described as selling, transporting, importing, furnishing, or possessing drugs for sale. Under Health and Safety Code 11352, it's a felony to sell or transport for sale substances like cocaine, heroin, or certain narcotics. Under Health and Safety Code 11379, methamphetamine and PCP fall under similar rules. Selling, transporting, or giving these drugs away can lead to felony charges. And even though adult recreational cannabis is legal, unlicensed selling or transporting marijuana for sale is still a crime under Health and Safety Code 11360. Across all of these laws, the key idea is intent to sell. Prosecutors rely on the amount of drugs, packaging, scales, payo sheets, large amounts of cash, or text messages to argue that drugs were possessed for distribution. Our job is to challenge those assumptions and hold the state to its burden of proof. Now let's talk consequences. For cocaine, heroin, and similar narcotics under 11352, a conviction is a felony with a typical sentencing range of 3, 4, or 5 years. But if you're accused of transporting drugs across non-contiguous counties, that range can jump significantly. Fines can reach up to $20,000. For methamphetamine and PCP under 11379, penalties include 2, 3, or 4 years for basic transportation or sale, and 3, 6, or 9 years if the drugs were moved across non-contiguous counties, and fines can go up to $10,000. For marijuana under 11360, small-scale violations can be misdemeanors with up to 6 months in jail. Still, larger-scale sales, transportation for sale, or cases involving minors can become felonies with multiple years of exposure. And then there are the weight enhancements. These can turn a short sentence into one that lasts decades. For heroin, cocaine, and cocaine-based, the penalties increase with weight: 3 extra years for more than a kilogram, 5 extra years for more than 4 kilograms, 10 extra years for more than 10 kilograms, 20 extra years for more than 40 kilograms, and 25 extra years for more than 80 kilograms. These enhancements stack on top of the base sentence. They don't replace it. What looks like a 3-year exposure can quickly turn into 10, 20, or more once enhancements are applied. If you're facing drug trafficking charges, the question isn't whether you can talk your way out of it. The real questions are, how strong is the state's evidence? Where are the weaknesses? And what can be suppressed, challenged, or undermined to protect you? One of the most powerful defenses is challenging the stop, search, or seizure. Many trafficking cases begin with a questionable traffic stop or a warrantless search. If police violated the Fourth Amendment or exceeded the limits of a warrant, we can file a motion to suppress the evidence. If that motion succeeds, the drugs, the money, the statements, and even phone data can be excluded. Without that evidence, the prosecution's case often collapses. Another defense involves intent. If the amount of drugs is consistent with personal use, and there are no indicia of sales like no scales, no packaging, no cash bundles, and no communication suggesting sales, we can argue you should not be treated as a trafficker. This may lead to significantly reduced charges for personal use or alternative sentencing options. We also challenge the alleged weight and the accuracy of laboratory testing. Enhancements depend on precise measurements. If packaging was included in the weight, if the chain of custody was broken, or if the lab made an error, we may be able to eliminate enhancements or even challenge the substance identification entirely. And in many cases, ownership and knowledge are major issues. We frequently see situations where a vehicle is shared, a bag belongs to someone else, or multiple people have access to the same space. If the prosecution cannot prove beyond a reasonable doubt that you knew the drugs were there and intended to sell them, they cannot prove trafficking. Even when the evidence is strong, negotiations can be strategic. We can work to reduce trafficking charges to possession, eliminate enhancements, or fight for sentencing alternatives where the law allows it. The stakes in these cases are incredibly high. A drug trafficking conviction affects far more than your freedom. It can drastically affect your immigration status, block professional licensure, limit housing and job opportunities, and affect family law issues like custody and visitation. And with weight enhancements, what seems like a short prison term on paper can quietly become decades behind bars if you don't have a defense team pushing back at every step. If you're being investigated or charged for any of these crimes, you do not have to face this alone. We defend clients who are facing serious drug allegations and feel like their future is slipping away. Our job is to protect your rights, challenge the evidence, and fight for the best outcome the law allows. Call us today for a confidential consultation. The sooner we get involved, the more options you have. And if you want to stay informed about how California criminal law really works, subscribe to this channel and turn on notifications. Your freedom, your record, and your future are worth fighting for. Let's start that fight today.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.